Hello friends, we are going to start section 313 CRPC, power to examine the accused. Subsection 1 says, in every inquiry or trial, in every inquiry or trial, for the purpose of this subsection tells about the purpose of this section, this section 313 CRPC. This section enables the accused personally to explain any circumstances. Any circumstances here means the relevant and fact in issue in appearing the evidence against him. This subsection enables the accused to explain the circumstances of the case to the court. Now, what will court do? The court may at any stage without previously warning the accused put such questions to him as the court considers necessary. Court at any stage without warning the accused put any type of question related to the case to him to examine the accused. कोर्ट कोई भी ऐसा क्वेश्चन जो कि रिलेटेड होगा केस से बिना किसी वार्निंग के पहले वार्निंग दिए अक्यूज को पर्सनली एग्जामिन कर सकता है. दिस एग्जामिनेशन विल बी डन ओनली बिटवीन द कोर्ट एंड अक्यूज. No other person will be present at the time of examination. At the time of examination. They are saying in next subsection, the court shall, after, they are using the word shall, after the witnesses of prosecution, this is important, prosecution have been examined, and before he is called on his defense, they are talking about accused, questions him generally on the case. They are saying what will be the stage of examination. We can understand this in every criminal case. First of all, there will be prosecution evidences stage. Next stage would be defense evidence stage. If prosecution evidences have been submitted, then burden shifts upon the defense. Burden of proof shifts upon the defense. This stage is the stage of examination of 313 CRPC. They are using the word shall. This examination at this stage is mandatory. This examination of 313 of accused is mandatory. कब मैंडेटरी है? जब प्रोसिक्यूशन एविडेंस सबमिट हो चुका है और डिफेंस एविडेंस सबमिट होने से पहले का जो स्टेज है उसमें एग्जामिनेशन ऑफ पर्सनल एग्जामिनेशन ऑफ अक्यूज्ड इज मैंडेटरी. Whether court can examine accused under section 313 at this stage? The answer is Yes, court can examine under section 313 at this stage. But at this stage, the examination of the accused is not mandatory. This 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 is the discretion of the court. Discretion of the court. We have to understand that court can examine the accused at two different stages. First, at the prosecution evidence stage, or prosecution after prosecution evidence stage. At this stage, examination is mandatory, but at this stage, examination of accused under 313 section is discretionary. Discretionary. Because in subsection 1, clause A says court may at any stage without previously warning the accused put such questions to him as the court considers necessary. तो कोर्ट को यहाँ enable किया जाता है. कोर्ट, this is enabling clause because the word may has been used, कि court can examine the accused at any stage but before the stage of the defense evidence stage. Now we have to understand the proviso. What proviso says? Proviso says in summons case has been defined under section 2, subsection W, where the court has dispensed. Means exempt with the attendance of the accused. It may also dispense with his examination. Summons cases ऐसे cases होते हैं. Now we have to understand what will be the summons case, warrant case and summons case. What is the difference between warrant case and summons case? हमें यहाँ लिख लेते हैं इस चीज को. यहाँ स्पेस नहीं है ज़्यादा. एक सेकेंड. हाँ. Now we have to understand warrant case and summons case. Warrant case, in warrant case, the offence is as such in which punishment is death, life imprisonment, or punishment of 2 years or more than 2 years. Section 2 subsection W says summons case वो केस होंगे जो वारंट केस नहीं है. Means summons case would be the case in which the punishment is either 2 years or less than 2 years. In this, now what proviso says, provided that in a summons case where the court has exempted with the personal attendance of accused, it may court को लगे अगर तो court may also dispense with his examination under clause B. मतलब ये जो mandatory examination है ये summons केस में mandatory नहीं है. कोर्ट ने अगर अटेंडेंस डिस्पेंस किया है, पर्सनल अटेंडेंस डिस्पेंस कर दिया है, तो कोर्ट कैन एग्जेम्प्ट हिज पर्सनल एग्जामिनेशन ऑल्सो. बट अगर कोर्ट ने इसकी एक्यूज की पर्सनल अटेंडेंस को डिस्पेंस नहीं किया है, then examination will be done. Next subsection says no oath shall be administered. Administered means किसी चीज अक्यूज को दिलाना, मतलब नो ओथ शेल बी एडमिनिस्टर्ड. कोई subsection 1. As we all know, oath cannot be administered to the accused unless he no oath to the no oath can be administered to the accused unless he has become a witness. Next, the accused shall not render himself liable to punishment by refusing to answer such questions or by giving false answer to them. Now, in the personal examination of accused can do what kind of thing? He can refuse to answer first. Second, what he can do? Second, what he can do? He can give false answers. Then will he liable? Section 313 subsection 3 says he will not be liable. Why he will not be liable? Because he is an accused. Let us understand this. If any witness who is appearing in the court refuse to answer, then he will be liable under section 179 of the IPC. If a witness appearing in the court gives false evidence, he will be liable under section 193 of the IPC. But section 313 subsection 3 says he will not be liable for giving false answers and refusing to answer. Q, because he is not a witness, he is an accused. He is an accused. Had he been a witness, then he would have been liable under section 193 and section 179. This is the difference between an accused and a witness. Next subsection says the answer given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him any other trial. This is important here. Any other trial into or trial for any other offense. Other offense which such answer may tend to show he has committed. They are saying in the present case, this statement, this examination cannot be treated as evidence, but in case of other inquiry or trial or other offense any other offense, it can be treated as evidence. But in the present case, this examination of the accused by the court cannot be treated as substantive piece of evidence. This is what section 313 says. Next, we will see section 311 in next video. Thank you for watching this video. If you have any doubt, you can comment and ask your query. Thank you for watching this video. Thank you.